Hello, everybody. My name is Jeff Faller with the Apartment Owners Association. And, we have several attorneys that write articles in our magazine and advertise.
What I hear from them is that about 85% of the time, when a
rental property owner writes the 3-day notice, 85% of the time it's not written correctly when they bring it to the eviction attorney. And so today we're going to be covering that. And before we get into it, the Apartment Owners Association has been around for over 40 years, serving California, and we are dedicated to your real estate success. And so that's why we do live streams like this. That's why we have the magazine. That's why we have 10 operators that you can call, or property management advisors that can help you with your property management questions. And we have the whole tenant screening department. So much that's going on. And speaking of tenant screening, gosh, if you are in LA County, I hope you understand that LA County court data, all of it has, the date of birth has been redacted from those court files. So just running a simple instant criminal search through Zillow or even through AOA is not going to show you much, because by law there has to, that information really has to be verified to be able to show it. And so I just want to say that, because I know that over 50%, I guess it's 50%, right at 50% of evictions started with some sort of fraud at the very beginning. And fraud being they didn't tell you that they were a criminal, they didn't tell you XYZ. And so just want to highly recommend that when you do use AOA tenant screening, or if you're not using AOA, just whatever you're doing, definitely get the single county. And as an AOA member, you can always get the single county criminal. But that's just we're going to be able to verify the date of birth and get the information to you, get you more information that's not going to show up on the instant. Instant criminal is great for showing everything that's happening across the country if they're coming in from a different place. But man, for LA County, Riverside County, some of these areas, it's basically half of California. That information is really tough to be able to show you legally. So all that to say, run the single county criminal report, please, and get the best tenant. That's what we want for you. So here we go. We're getting into this. We do have a event coming up tomorrow, in person, free parking, free lunch, and it's 3 different seminars in San Diego. So if you are in San Diego, definitely come out. One of the speakers will be talking about estate planning, and that should be a great time. I won't go into too much more. Next week we'll talk about new laws for 2024 that you need to be aware of, so tune in for that next week. And just getting into this here, if you're watching this from AOAUSA.com, there's a blue help button where you can put in your questions, but just save everything until our speaker finishes, and then he may answer your question, and then at that point, putting your questions in will be better. But our speaker today has done over 250,000 evictions, and he's been in the business for 45 years plus, has 24 attorneys on staff, and is based here in the Los Angeles area. And anyway, he's the founder and president of Dennis P. Block and Associates. So it's my pleasure to bring Dennis Block on. Hey, Dennis, how you doing? Okay.
Is muted, so I couldn't get to see you. I know the audience here certainly wants to see what you look like. So you might want to hit that button. Make sure you're broadcasting. But I want to thank everybody for coming in and participating in this Zoom video. I did want to mention that I do have a Zoom meeting that I do myself there you go, Jeff, that I do every Saturday at 3 p.m. Still trying to get Jeff to join me. One day he'll consent. But if you go to my website, evict123.com, and you'll be able to join that meeting every Saturday at 3 p.m. And if you've got questions, we're happy to answer them for you. And maybe if we don't get to them today, you can catch me on Saturday. So today's lecture seminar is going to be about preparing and serving a 3-day notice to pay the rent. And as Jeff was mentioning, it is so easy for landlords to make mistakes now where either we have to start it all over again, or if this lawsuit is filed and it doesn't have the proper notice, then the lawsuit is doomed. A notice, like a notice to pay rent or quit, is similar to the foundation of a house. If you build the Taj Mahal on a bad foundation, regardless of how nice that the house is, you're going to have to tear the house down. And the same thing is true with an unlawful detainer action, an eviction action. If you have a bad notice, then it is not in conformity with the laws, then you will lose your case. It's as simple as that. It doesn't matter that the tenant owes you 3 months worth of rent, has no excuse. It doesn't make any difference because these cases are designed to be technical, and they're designed to be technical for one reason only, and that is for landlords to lose their cases. In the days when I first started practicing law, and by the way, you made me out as so old, Jeff, the way you said that, 45 years. I can't even believe it myself. Hopefully I can get out of this chair after the broadcast, but without any help. But when I've seen what I've seen in the last 45 years, it was relatively simple for somebody to get a handy dandy 3-day notice form. And, you post one on the door and mail one if the tenant wasn't home. And that was it. No mistakes. And it was pretty simple. Right now, it's like a gauntlet trying to prepare and serve a notice and knowing all the rules. I'm telling you, ladies and gentlemen, you almost really have to be an attorney. And that's why I think these types of seminars are so invaluable. So at least you can serve these notices by yourself with a little bit of training. But trust me, there is so much to know with regard to this. So let's get into this as to a notice to pay rent or quit. And you would think that I would start by telling you how to fill out the notice and how to serve the notice, but I'm not going to start there. Why should I? I'm going to share my screen with you right now. And you're going to see is before, let me see if I can make this a little bigger so you guys can see it. I think so, yes. So before you can even think about serving a 3-day notice, you have to understand something about the fair market value, or as our wonderful politicians call it, they call it, quote, the threshold. So what's that all about? Well, this only applies, so make a note of this, this only applies to the city of Los Angeles and unincorporated areas of LA County. So unincorporated areas of LA County that are not part of your municipality and the city of Los Angeles, you first have to determine before you can even get out your 3-day notice, can I even prepare one and serve one now? So for example, for a 1-bedroom apartment, it says here, $1,747 is the fair market value. So you would think what that really means is that anybody whose rent is below the fair market value that the city would, or the unincorporated areas of county would allow you to raise your rent to fair market value. I mean, that's what it's called, fair market value. But of course, it has nothing to do with landlords raising their rent, zero, even though they're acknowledging that that's the fair market value. But in any event, if your rent for a 1-bedroom apartment is $1,500 and the tenant hasn't paid you for the month of November, don't even waste your time filling out a 3-day notice because you're below the threshold. You're below the threshold for a 1-bedroom apartment, which means that you'd have to wait until December. Now, in December, the tenant will owe you 2 months rent. So that's a total of $3,000. And then you're above the threshold. then you can proceed forward with it. But if you think about it, the elected officials for both the County of Los Angeles and the City of Los Angeles is basically encouraging every landlord whose rent is below. You think they would be thankful that your rent's below because they're really trying to get lower rents, but that's not. No, you're penalized because you have to wait. And if the tenant wants to pay his rent on the 25th of each month, then what that means is that you're going to have to accept it. It's the full payment of rent. So the first thing you need to take a look at this chart, and you might want to take a snap of it. And though I think I have it on my website, and I'm sure the Apartment Owners Association has it on their website, AOAUSA.com, I might add, and make sure that you're above the threshold. Now, I would recommend for landlords out there not to take a partial payment, because if you take a partial payment, let's pretend the rent is $1,750, but the tenant walks up and gives you $1,000. Well, now he only owes you $750, which means you can't serve a 3-day notice. So don't take a partial payment, and you're going to have to wait till the second month, assuming you're below the threshold, in order to proceed. The true abuse case is where your tenant is on Section 8. Now, that's an abortion. And I say that because if the rent is $2,000 for a one-bedroom apartment, but we all know if you're on Section 8, that's subsidized rent. And in this example, we're going to say that Section 8 pays $1,800 and the tenant has to give you $200. But if the tenant's not paying you their share, of course, you're going to have to take the rent from Section 8. So how are you going to be able to serve a 3-day notice? In the month of November, he owes you $200. In December, he'll owe you $400. So you're going to be below the threshold unless you wait 9 months. So the City of Los Angeles, and of course the unincorporated areas of LA County by our county supervisors, have basically said, if you're a Section 8 tenant, don't worry about paying your share because you're never going to be above the threshold. So that's the first thing you have to determine. Let's stop sharing this. Thank you. That's the first thing you're going to have to determine when you're preparing or thinking about preparing a notice to pay rent or quit is, do I have the right to do it? Now, if I'm in Culver City, if I'm in Long Beach, if I'm in Redondo Beach, if I'm in Glendale, if I'm in Burbank, and the tenant owes you $100, there's nothing from stopping you from serving that 3-day notice for the balance of $100 because they don't have this threshold. So it's only those jurisdictions, which I mentioned, which is that dastardly city called Los Angeles, and also, I love Jeff, and also the unincorporated areas of LA County, where this has to be considered with regard to the threshold. So let's move on from that. So let's pretend that, thank God, we're above the threshold. So now what we have to do is we have to fill out something called a 3-day notice to pay rent or quit. And I certainly recommend the one that the association has. I certainly helped a little bit preparing that. And I'm going to now share my screen and we'll take a look at their wonderful notice. So bear with me as we hit the correct button here. And there we go. So this is their 3-day notice. It says underneath it, the City of Los Angeles. I know we're going to be changing that. And we're just going to have one notice for all jurisdictions. We might have to put a little extra stuff in the notice, but it's okay. This way, there'll only be one notice and you'll fill it out and it's pretty simple. So let's start with this right now. Let's see if I can make this a little bigger for your viewing pleasure. And again, this part here will be changed. This is going to be for all areas, and you can use this form even if it says the City of Los Angeles, but shortly they'll be on their AOA website. It'll just be one 3-day notice to pay rent or quit. So the first thing is you have to put in the names of your tenants. So I'm going to just type in John Smith. Well, what names do you go there? So people are not exactly sure. I mean, if you got one tenant, that would be pretty simple. I'm going to put in John Smith. But what if, he's got other people living with him and he's got children? Do I put all those names in? How does that work? Well, what happens in that situation is you're going to put in the names of all people who signed the rental agreement. So their children didn't sign the rental agreements, forget the children. Or people who pay you the rent. So if you had another person who's occupying the premises, even though he's not on the rental agreement, he's paying you the rent, you're happy to get the rent, you like the stranger even though he's not on the rental agreement. But if he's paid you rent and you've accepted that, then I want his name in this notice as well. So you're going to put that person's name right there. I can't type today. Okay. So you're going to put that person's name there. This form allows for 4 names. Quite frankly, that's probably enough. But if not, then you could always double it up. Let's see. And put another name there if you need more space on these forms. And these forms, by the way, are wonderful because they're fillable. So you don't have to have a typewriter. I don't even know if anybody knows what a typewriter is these days. We used to have them many years ago. But in any way, you would fill that out and put in again all the names of people who signed the rental agreement and those people that who pay you the rent. Now, what if you have a situation where you leased it to A and B's been gone for a year? I mean, the person's not coming back. So in that situation, you do not want to put B's name in here. You're not going to be suing them. It doesn't make any sense to sue them. If you tried to sue them after the notice expired, you'd file an eviction lawsuit called an unlawful attainder. You'd have to serve them. You don't even know where they are, and you can't serve them by just merely serving the remaining tenant. So again, just put in the names of the tenants who pay you the rent or who signed the rental agreement. Let's move down to this spot here. And this is where you put the address in. And then, of course, you might make sure that you have the unit number. If you don't, let's put a number in. Then, of course, you're going to put the city in. And finally, you're going to put a zip code in. Now, if you make a mistake and you misrepresent the address, there's a typo in the address, you're going to lose your case. If you don't have an apartment number, you're going to lose your case. Or the right city or the right zip code. These will all be reasons why you lose your case. So make sure that you fill this out completely and accurately. Now, I've got a question for Jeff because I have to put him on the spot. Jeff, if you have a case where it's street, but you wrote avenue, are you going to lose your case?
Yes. Am I right or wrong?
Correct.
Okay.
But I want to ask you, do you know what they call either if it's an avenue, a street, a circle, a lane, a road? What are these all called? Do you know?
What would you call them?
Do you give up?
Pretty quickly here, yeah.
And, I had to look that up. We all know what that is, right? Avenue, street, road, lane, circle, right? But what do they call that? What is that? And I had to look it up myself, so I don't want to seem like I'm some sort of a genius and know everything because I don't. But that's called an address suffix.
Okay.
So, and you can win this. If you see this on Jeopardy, you'll know exactly how to answer that question. Or you can do this at a party and you'll win a lot of money because nobody knows the answer to that. Now, let's move on. For unincorporated areas, you're going to see here the number of bedrooms. And we're going to put that into all of our notices. Again, it's really only applicable for unincorporated areas of LA County and the city of Los Angeles. You don't necessarily have to fill that out for any other address, but we're just going to leave that form there, and it doesn't hurt to fill it in if you're not in those 2 areas, or you can fill it in and it's no harm, no foul. So why does the city of Los Angeles and unincorporated areas of LA County require that you put in the number of bedrooms? Well, because they want to make sure that you're above the threshold. Remember, the threshold was that it was $1,747 for a one bedroom. I think it's $2,222 for a three bedroom and $2,888 for a three bedroom, and down the list here. So they want to make sure that a judge or the city, if you're sending this information into the city, which we'll go into, they want to make sure that you can tell instantly whether you're below the threshold or not, and whether your notice is defective. So in the city of Los Angeles, unincorporated of LA County, if your notice doesn't have the number of bedrooms, then you will lose your case. They will throw you out faster than you can spit. Now, one of my associates wrote the number of bedrooms. This was just yesterday, and I had a discussion with this wonderful attorney. And this particular unit did not have any bedrooms. It was a studio unit. So she wrote studio, number of bedroom studio, which I think might go through it. But quite frankly, I told her I don't want to take a chance that if they're saying number of bedrooms, they're looking for a number. So in that situation, you want to put, ladies and gentlemen, if you can see that, zero bedrooms. Okay. Okay. The other curious thing is if you're renting rooms in a house, which is not exactly proper, but if you are, then I would put only one bedroom, since the tenant is only renting one bedroom as opposed to all the bedrooms that are in the house. Okay, let's move on. Let's pull this up a little bit. This is the total amount of rent that is currently owed. The total amount of rent that is currently owed. That goes in this figure here. You're just going to write it like in letters, $3,000, and then you're going to write over there 3,000. This is pretty simple to fill out. However, we have to understand that there is certain rules in the city of Los Angeles and also unincorporated areas of LA County where you can't, I'm recommending, do not ask for rent prior to April 1st of 2023 in a 3-day notice. Number one, you're going to have to serve either a 30-day notice to cover the county laws, or you're going to have to serve a making sure that they didn't put any admonition that they were affected by COVID for each single month. So right now, I mean, unless you're going to get advice of an attorney, and for the purposes of this Zoom webinar, I would just go back to April. So right now it's April through November, and that's a total of 8 months. So, or any portion thereof. So put that in, just make sure that you're above the threshold. And of course, on the AOA form, you would put in the specific months that were owed. That would be from here. We'll do, let's see, September. We'll put in September 1st, 2023. And then, and this would be again to September 30th, 2023. We put 1,000 here for October 1st, and then finally November, and that's how we're going to get to the $3,000. And just fill out the other side of it. I'm not doing that, but these should be filled out with the years in these spaces here. Again, if you are computing what the rent is, this is, let's take a look at the top. This is a 3-day notice to pay rent or move out. It is not a 3-day notice to pay rent and refrigerator charges. It's not a 3-day notice to pay rent and the garage charge. It's not a 3-day notice to pay rent and late charges. It's rent and rent only. Okay. And by the way, for those sneaky landlords out there who says, well, the guy owes me a $50 late charge. So you know what? I'm going to take his rent's $2,500. I'm going to apply $50 to that old late charge. And I'm going to say that he only paid me $2,450 for the current month. Sneaky landlords, you're going to lose your case on that basis. So when a tenant pays, he's determining, which is the debtor determines what debt he's paying. The creditor doesn't apply it to whatever the hell he feels like. It's the debtor, that would be the tenant, who pays, and he determines. So make sure that you're asking for the correct amount of rent, and also make sure that you're asking for rent and nothing else. Rent and rent only on these. I wouldn't include SCEP charges for those people in Los Angeles, or the registration fees. Those are called I don't know, rent excess or surplus. And I don't know, judges are skittish with that. Just ask for rent and nothing more. Also, we have to have this phrase in here, and I mean this phrase, that's all up and down the state of California. That is that when counting 3 days, you exclude Saturdays, Sundays, and legal holidays. So let's pretend we have a situation where, and that's language has to be in the notice. If it's not in the notice, you lose. I don't care what jurisdiction you are, up from Sacramento down to San Diego, you will lose your case if somebody points this out to the judge. And trust me, they all point it out to the judge. If you serve a notice, for example, on Friday, and Monday is a legal holiday, oh my God, do you have to count? Okay, well, first of all, the day you serve the notice is day 0. Now, we know Saturday's not going to count, Sunday's not going to count, and Monday was a holiday, so that's not going to count, which means the tenant, day 1 would be Tuesday, day 2 would be Wednesday, day 3 would be Thursday. So the tenants would have until Thursday midnight to come up with the full amount of rent. You do not have to accept the partial payment. And then we could proceed forward with an eviction on Friday, or you don't have to accept rent as of Friday because that's beyond the 3-day period. So also thinking about this is that a lot of clients will say, well, he can always come to court and pay the money there or pay the money afterwards. And as long as he comes up with the money, then I really can't do an eviction. And my answer to that is this notice, let's go back up to the top again. This is called a 3-day notice to pay rent or quit. It is not called a 3-day notice plus whatever the hell I want to pay it. Okay? It's just a 3-day notice. So based on that, the tenant would only have, in my last example, till Thursday midnight to pay. You do not have to accept the money on Friday. And if the judge merely follows the law, you should prevail in your eviction case. Okay, so we went through the who goes into the notice. We went about the address and making sure that that's correct. If it says south, you better write south. We all know now about what an address suffix is, and you better get that correct. The bedrooms, the amount of the rent has to be stated. Again, no other charges in that. We also know that the rent has to be paid on Saturdays, Sundays, and legal holidays. You do not count days for that. Let's move on, okay? You must be able to tell the tenant the following in that notice, or it's defective up and down the state of California. And that is who to pay the rent to, okay? Who the rent should be payable to, the person, and I'm emphasizing the word person, who the payment is to be delivered to, that person's address, the zip code and telephone number, and the days upon which you're able or willing to accept the rent. Okay? If you have an LLC, for example, that holds title to your property, in this example, we're going to call it XYZ LLC, that's who you want the check made payable to. But if you don't have an individual's name right here, okay, If you don't have an individual's name right here, you will lose your case because this is an entity. That's who you want the payment made to, like a check or a money order, cashier's check, etc. But this is the guy who you deliver it to. And you also have to have an address where to deliver it to. What you can't do is the following. If you write something like that in your notice, you will lose. The tenant has to have an address or a place where he can pay the rent. So that's a no-no. Can it be a P.O. box? And the answer is yes, it can be a P.O. box. If the tenant does mail it within the 3 days, even if you don't receive it, that's considered proper service within the 3-day mailing, within the 3-day period, as long as he pops it in the mail. But it can be a P.O. box. Again, you have to have a phone number. If you don't have a phone number, I'm going to give him your cell phone number, Jeff, okay?
That sounds great.
Is that okay?
You gave him my real number.
So if you don't have a phone number, then your case will be lost. Again, you need to have an address, which is not the property address, unless you happen to live with the tenant. You have to have an address where you can go, or it could be a P.O. box. Make sure you have the zip codes. Then you also have to say here, which we say in our notices, Monday through, let's say, Saturday. And the following hours, and I would write 9 to 6, or 9 a.m. I should actually write, to 6 p.m. Now, can you have the tenant Zelle you? Because I get this all the time. And I'm actually now a big fan of Zelle these days. So I actually give my tenants my Zelle credentials so they can just throw money into my account. Some of the problems with Zelle, though, is you don't really know who it's coming from. But certainly that is permissible for a tenant to pay it that way, but it makes your notice defective. You can't say Zelle on a notice. What you can do is you can tell them in the notice that your payment is payable to this person, but what you would do is you would write, you can direct deposit to my bank. You have to write the name of the bank. Okay, you still have to have a person here. Let me see if I could do it on your notice. I have one that's specifically for banks. Direct deposit to Wells Fargo. And then you'd have to have here account number. Got to put the account number. Okay. Then you'd also have to have the address of the bank. You have to have the times when the bank is opened. So the address of the bank, the times of the bank is open. So maybe it's 9 to 5, Monday through Friday, and 9 to 12 on Saturdays. Do you notice how banks aren't open anymore? It's crazy. Bank of America closing like at 3 o'clock. How do you even get to the bank at these days? But in any event, you have to have once again, the name of you have to have an individual's name, which is yours. You have to have your phone number, but you have to have the name of the bank, your account number, the hours that the bank is opened, and you can just go on Google to do this. But more importantly, you have to have a bank within 5-mile radius of your property. So how do you do that and figure all that out? Well, that's actually really simple. If you have if you know the zip code of your property, which of course you do, what you do is you write, let's say Bank of America, this is in Google, do Bank of America space and then the zip code and hit the enter button. It's going to pull up the address of the bank that's closest. It's going to also give you their hours. So you click the little hour button, it'll tell you Monday through Saturday when that bank is open. So that's an easy way to determine that your bank is within 5 miles. Technically, if it's not within 5 miles, you bank at some crazy bank and there's none in the area of your building, then you are not going to be able to tell them to a bank account, okay? You could give them an address, and then you could also say, or pay my bank. That's fine. Or you could say, here's an address to pay me, or Zelle me if you want. that's okay. I mean, a lot of management companies and have this Appfolio app where you can directly deposit. And I think actually the best one, the AOA management software, allows you to do that too. And of course, you encourage tenants to do that, but you still have to have an address where they can deliver the money to if they want, or a bank and their address. So that allows you to be in compliance with the law. Let's see here. Did we go here? Let's see what's down here. I think this is like a duplicate of what's up here. Am I looking at this wrong? Occupied by, yes. I think we got some sort of a duplicate here where they're asking you to put it in again. But you are located in the city of. We'll talk about that, Jeff. I think you have it in 2 places. Oh, I see. This is the address. I'm sorry. This is the address. No, but you have it up here. You have it in 2 places. But the as long as you comply with those requirements, then you will have filled out the notice correctly, and you won't get your attorney saying, nope, you didn't do that correctly. We're going to have to restart this case all over again. Let me stop the sharing here, and let me get this pulled down. So we now know what's required with regard to the preparation of a 3-day notice. And so we're going to do that, and we serve it. We wait 3 days, and then you call my office or another attorney's office, and you've already lost your case. Well, how is that possible that I lost my case? I did everything you said. I watched the seminar up to this point. Could there be more, ladies and gentlemen? And the answer is yes. So not only do I have to tell you how to fill out a notice, I got to tell you all the other little tricks that they have. So let's start with this one. Okay, as I wait for this to populate, let me do this, and then we're going to share our screen again, ladies and gentlemen, here. Okay, let's get rid of this. Get off my screen, please. Thank you. Okay, let's do a little more sharing. Okay. Okay, so if your property is subject to RSO, so you're under the LA Rent Stabilization Ordinance. I'm not talking about unincorporated areas of LA County. I'm not talking about Burbank or any other Long Beach. I'm just talking about the city of LA, and your property is under RSO. This 1-page form, and we just recently found this out, by the way, has to be posted on your property in a conspicuous spot. So if your property is subject to RSO, that is, it's multi-unit and it was built prior to October 1st, 1979, you've got to have this notice posted in a conspicuous spot on your property. Now, if your property is residential property, whether it is or isn't under RSO, and I'm talking about even a single-family home or a brand new building, I don't care what it is, any residential property in the city of Los Angeles, you also have to post this form, which is the City of Los Angeles Renters Protection Notice. Oh my God. And this is a 2-page form. So all these 3 pages for RSO properties have to be posted. But this form, and again, these forms are all on the AOA website. They're great. They're up to date. Everybody knows what they're doing. You post this too for all residential properties, unless they're under RSO. If they're RSO, then you have to also post this. If you don't have this notice posted and you serve your 3-day notice and you go to court, you will lose your case. So let's think about this. If I have a condo in a big building, I got one condo, and it's brand new, it's not subject to RSO, but we're located in the city of Los Angeles, then I've got to serve this 2-page notice because I'm not under RSO. I'm not serving that one. I'm going to serve this one. And so where am I going to post this? This is a condominium. I only own this 1 unit. Well, whether you like it or not, go down to where all the mailboxes are and post it there, or you can post it by the tenant store and take a nice picture with your cell phone so we can prove that it was up. I'm sure someone's going to rip it down. That's okay. But if you're around the building, put it back up. But it's got to be listed. Even if you have a mansion in Beverly Hills that you're renting out in Brentwood, you've got to have this form in a conspicuous spot on the property. And if you don't have this form, this is this one, because you're not going to be under RSO, you will lose your eviction case. Even if you're not going for non-payment of rent, you have to have these forms posted. Otherwise, you will lose your case. Again, we're talking about the city of Los Angeles only. And the requirements are pretty harsh if you don't do that. So you don't want to lose your case on that basis. Now, if you do have that notice posted in the city of Los Angeles, you filled out your notice correctly, you waited 3 days, you were above the threshold, I got my street suffix in there correctly, whatever that means. I think we all know that now. Now what? I'm going to give my case to the attorney and I'm going to lose. Lose? How am I going to lose? I followed everything you said. There couldn't be something more, could they? Well, yes, ladies and gentlemen, there is. So if you don't do this last step for the city of Los Angeles, and we'll get on to the other ones, okay? If you don't do this last step, you will be a wonderful loser, ladies and gentlemen. So here is the form, and this is called the eviction notice filing for the city of Los Angeles. Eviction notice filing for the city of Los Angeles. Oh my God. You've got to, when you serve the 3-day notice, within 3 days of the service, you've got to fill out this form. We're only talking the city of Los Angeles. And then you have to send that into the city with a copy of the notice. So there's the form. You fill that out. Now you can do this online. And I know on my website, I have the website that you can do it with the city. As I've said in previous telecasts, that we don't like to do it electronically. We like to send it in to give the city a bad time. Right now, I heard that they were 6,000 notices behind in terms of entering them. And, you know, we had a conversation with somebody at the rent stabilization office, and we said to them, well, what do you do with all these notices that are sent into the city? I mean, after all, most time you serve a 3-day notice, the tenant's going to pay you. So what do you do with these notices? And the person was honest, and he said, we do nothing. We just log them in. So why would you want us to send them in if you're not doing anything with it? And of course, the person didn't want to answer, but the truth was, he did that for one reason only. This is the city. They wanted you not to do it, or not to do it timely, and therefore your case will be ruptured. You will lose your case, and you'll walk out of court in tears, having to start the case all over again. So make sure that you fill out this form and send that into the city. You can, I think the form has it right there, where you can do this electronically if you don't want to be sending it into the city. So that's basically for the city of Los Angeles and their requirements for doing notices. But as we move on, finally, what about other municipalities? Do they have rules, or is it just Los Angeles? Well, ladies and gentlemen, you're not going to believe this list. Let me pull this one up. And I made a nice list for you today. Let's see, is this it? And yes, it is. So, ladies and gentlemen, I'm going to share my screen for the last time. Okay, there we go. These are the cities that have, let me see if I can make this as big as possible for you guys. Oh, that's too big. Okay, these are the cities that, number one, have special requirements with regard to a notice. We got Culver City, Inglewood, in addition to the city of Los Angeles, Culver City, Inglewood, Santa Monica, unincorporated areas of LA County, Cudahy. It's like 20 blocks. Why do they need this garbage? They voted it in. Bell Gardens, Montebello, Pasadena, Santa Monica, West Hollywood, and believe it or not, Pomona. These all have special requirements that you have to send in this, like in Cudahy, within 5 days, if you can read this, within 5 days of the service of the notice, you have to send it to the city of Cudahy. There's their address there, by the way. Certified mail return receipt requested with a proof of service. If you don't do that, some smart tenant's attorney is going to know this law and you're going to lose. Unincorporated areas of LA County, you've got to send this in. You have to send into Santa Monica all notices except rent. Inglewood, you have to just mail it in within 3 days. Culver City, within 5 days with a proof of service. Literally, you have to take a college degree to figure all this out. So really know what jurisdiction you're in. And this is actually on my website. I don't know if it's on Jeff's website. Do you have this on your website, Jeff? Unmute, young sir.
Yeah, I don't know if we do.
Okay, well, it's on my website. And you know what? I bet you by tomorrow it's going to be on the AOAUSA.com website. But it tells you all the addresses for all the cities. And also, if you're going to serve like a notice to perform or quit, for the Culver City, it's a 10-day notice. Unincorporated areas of LA County, it's a 10-day notice. So you can't serve a 3-day notice. It's got to be a 10-day notice. There's no way that you can, navigate through this minefield to survive in an eviction case. They're almost forcing you to use the services of an attorney. And I'm not saying that to get more business. And that's why I'm here trying to educate you guys. But it is almost impossible to navigate this. And they've done this for one purpose only, ladies and gentlemen, and that is to make landlords lose their case. So in addition to the Los Angeles cover sheet, just make a mental note for where your properties are: Culver City, Inglewood, Santa Monica, unincorporated areas of LA County, Cudahy, Bell Gardens, Montebello, Pasadena, Santa Ana, West Hollywood, and Pomona, and coming to a city near you, wherever that might be, because these politicians just can't get enough of trying to ruin our property rights, just taking away the basic right of a person to own property. Let me stop sharing here. So this basically has gone over as best as I can the rules and requirements for the city and municipalities in the county of Los Angeles. A lot of it, of course, complies with also all other counties: Orange County, Ventura, Riverside, and San Bernardino, and of course, up north, unless you've got a local rent control ordinance there that you're going to need to follow. So at this point, Mr. Jeff, do you have any questions, or do you want to open it up to questions?
Yeah, we'll have questions here. Thank you very much for sharing all that. And yeah, like when we put those forms for LA City, there's a packet, and I think LA County has a packet as well, because there's just so many different things that you have to do all at the same time, and it's kind of crazy.
Before we start, one thing, because you just brought it to mind, one exception, and this goes for anywhere in the state of California. If you have a Section 8 tenant, oh my God, you're going to have issues dealing with non-payment of rent, assuming you're not having a threshold problem. The standard 3-day notice to pay rent or quit cannot be served on a Section 8 tenant. It has to be a 3-day notice to pay or 30-day notice to quit. Mm-hmm. It's like a hybrid 330. Now, this form is on the AOA website. You also have to include language from the CARES Act. Don't even ask me. But it's some language that, again, is on the AOA website. So make sure that you include that. So just make a mental note. If you're serving a notice to pay rent on a Section 8 tenant, don't use any of the standard forms. You've got to use the AOA forms dealing with the 30-day notice, 3 days to pay, 30 days to quit. And you also have to attach to this, I got about 15 pages worth of the CARES Act to be in compliance with some crazy federal law. But let's open it up to questions, young sir.
All right. Yeah, let's do this. Thank you. Thanks again for sharing all that. And I'm just glad we covered it. And again, this is it's hard to call this legal advice because I'd say this is not legal advice because your specific situation could be different and there's just too many things, too many moving pieces, like you said. So this is general guideline, but not legal advice. Nicole here, a landlord sue the city of LA for rent due from tenants? All assistance programs are tenant based, and if the tenant doesn't cooperate, there's no way to participate. I'm afraid small claims alone will not help. And so we have had some of the larger landlords sue the city, but I don't think it's gotten very far. Dennis, what do you want to add to that?
Yeah, I don't think it has gotten very far. I mean, if the tenant doesn't want to participate, the tenant would be considered, let me think. Oh, I know, a fool. Because if you could get someone to pay your debts for you, who wouldn't do that? You know, hey, mom, can you pay my debt? Yeah, sure, no problem. So why not let the city? So what is the motivation of a tenant not to want to participate in a program where he hasn't paid the rent, he owes the rent, and if you participate in this, you're not going to owe the rent? Well, they're just fools. It's as simple as that. Or they can't get anything together in their life to participate in this, and they'd rather you chase them, which of course you have the right to do. If you don't get it from a governmental agency, then the tenant's going to owe you the rent, and you have the right to sue them for that.
Okay. And, you know, I wish that there were recourse, but it stinks the way that things are right now. And okay, on YouTube, Realtor Slayer, what happens if a landlord refuses to fill out the assistance paperwork for a tenant who is behind? So that's kind of
in reverse.
Yeah.
A landlord doesn't have any obligation to fill that out, just like a tenant doesn't have any obligation. And the tenant can't say, well, you didn't fill it out, so therefore I don't owe you the money. That doesn't work. There's nothing in the law that says that. But I would encourage landlords to do that. I mean, just like the tenant, if you can get paid, why not?
Mm-hmm. And it's just a thought that came to my mind as well. But like, even there's other little booby traps on this thing too. Like even if the rent registry, right? Like if you're not current with that, then that's also a problem. There's other things that we have not mentioned in this thing.
Of course.
The whole thing, if you're not under RSO, how you needed to say whether that on the rental agreement, we have a place where you either mark it as exempt from California rent control or not exempt. It was known as AB 1482. Now it's changing with 567 coming into effect this next year, right?
Yep.
So there's more to it, right? So much more. So YouTube, David, can I post and mail 3-day notice to pay or quit? My tenant doesn't answer the door. How long do I have to wait to start after the notice is sent and posted?
Okay, I'm actually glad you raised this question because I didn't talk about how to serve the notice. To serve a 3-day notice or any kind of a notice, you'd be walking over to the door, knocking loudly. If no one answers, then you can post one on the door and mail one by regular mail. Once you finish mailing it, that would be considered day 0. And then excluding Saturdays, Sundays, and legal holidays is how you would count the rest of the days. There is also a little known law that says that if you can't serve him at the premises, you have to technically try to serve him at his place of employment. In most situations, you don't know where he works, so you can't really serve him there, but technically that's what the law states. And then if you can't serve him at the residence and you can't serve him at the place of employment, then you're allowed to post one on the door and mail one for each tenant whose name appears in the notice.
Right. And that's interesting. You said knock loudly. So are you saying almost beat the door down, or what's knock loudly means? Just because I think I don't want people to take that too far or whatever.
Well, I'm not saying it for purposes of trying to annoy the tenant. I'm saying it really for legal purposes that the court has to determine that you really did try to serve the notice personally. And when you couldn't, then you took the second route, which is required. It's in that order that you have to knock on the door. If you come over there and, and you hit the door with your fingertips so that nobody can hear it, then that's not going to be in compliance with the law. So you do want to knock loudly or ring the doorbell and see if anybody comes to the door. If they do, you hand it to them. And by the way, if they don't want to take it from your hand, drop it at their feet and walk away. That's considered personal service.
And you asked there's a question about the time of the day. You had mentioned midnight. What if your lease stipulates 5 p.m. as far as when things are due? Like, legally is that effective if that were on a lease agreement, or how would you?
It would not be effective. So the tenant has 3 days, 72 hours to pay. Again, the day you serve it is day 0, and then they have till midnight of the 3rd day. The fact that you're saying your hours are such and such, only from, let's say, 9 to 6, well, that's great. But if the tenant comes at 7 p.m., technically that would be considered proper. Now, people say, well, the landlord wasn't home. Well, but the reality is the landlord home when the mailman comes, every single day? And the answer is no. So can't the tenant leave it by the door? I mean, unless it's cash, I guess you could leave it by the door. Or tape it to the door so that the landlord's in receipt of that.
Great. All right. Sevi on YouTube. Will that threshold be adjusted yearly? And the answer is yes to that. Right, Dennis?
That is, because it's based on the HUD qualifications for what the fair market value is for that type size unit in that county. But again, I go back to my point, is if the city and the county are relying that this is the fair market value for, let's say, a 1 or a 2 bedroom, then why can't we raise it to the fair market value? So I think they shot themselves in the foot. They also shot themselves in the foot because any landlord who is renting out a unit that's vacant, if you charge less than the fair market value, you have to have your head examined because otherwise you're going to have to wait more than 1 month for your rent. So on that basis, you want to make sure that you're above the fair market value. So for a 2-bedroom, I've got to get more than $2,222. So what is the city and the unincorporated areas of LA County encouraging landlords to do? And that is to make rents less affordable. But isn't it their job to make it affordable? Basically affordable on your back, by the way, your financial obligations, not theirs. But anyway, that's what they have done with that fair market value theory.
And then also keep in mind, that was really a good question that they asked about that, what happens every year. And so that notice is going to have to be updated every year as well, because the numbers that are listed there for market rate, it's going to be different it's going to be different from what you have in the notice from 2023 come next year when they update that.
No question. But then again, that's only a calculation you're doing in your own mind. The 3-day notice form will stay the same.
Right. No, the tenant protection notice has it in there, right?
Oh, that's true.
Yeah,
that is true.
That's the one
they'll make us do it. And then we'll have the wrong notice up because we were 3 days late and we lose our case. They have made it impossible to go forward with an eviction. After you get past all those areas dealing with those requirements, and of course, in every single case, the tenant's going to complain that the premises was uninhabitable. And it just goes on and on and on, just making it so much more difficult for owners to operate their buildings. And then even if you're doing everything fine, you're still going to get a lawsuit for habitability that your premises were uninhabitable. So it's really a sad state of affairs. I was just stating to someone the other day that I'm not investing in California anymore. I just did a big investment in Las Vegas actually yesterday. But this is it for me for investing any further in California. I just don't think it's worthwhile. But, as I stated, we're kind of stuck here. We have our family here. We have our property that we already own. So we're somewhat stuck here. But I'm not a big fan of investing in anywhere in the state of California.
Yeah. It's kind of a downer there, man. Kind of a downer. But yeah, I know a lot of people are frustrated for sure. And it's so crazy. Like I was down at City Hall 2 weeks ago with when they were in the housing committee and we were trying to stop them from, extending the rent freeze. And then they came up with a dumb idea of making it 4%. Like, how is that even fair? But anyway, like people were sharing our side, and then tenant rights group people were like, well, then just get out of the state. And I'm like, do you want me to tell you how many people have gotten out of the state already? Like people actually are getting out of the state with their rentals, and they just don't understand that if you don't treat money right, treat investment right, that it will flow to other places.
We're housing providers. We perform a valuable service. We're not to be vilified. We're to be revered for what we do. Our industry is the best industry. It helps so many people, and we're entitled to a fair rate of return.
That's right.
And there shouldn't be any kind of governmental intrusions. You can't sell a $1 million house for $2 million. No one is going to buy it. So the market is a wonderful way that our economy works, that the market determines what the price should be. But our politicians and these tenant groups that are just looking for someone else to pay their bills for them are just stacked up and waiting in line.
Yeah, it's kind of scary because that word market, what it really means, it's the determination of the people or the will of the people. But when they talk about market, they talk about, forget market, and what they're saying is really forget the people, forget the will of the people. We want to set it. And that is just, horrible. Here we go. We digress. Okay, June, is there a threshold for an SRO building, just one bedroom without bathroom or kitchen facilities? So which threshold number should they use there? Studio, or should it just be the one bedroom?
Well, if it's I don't know, if it's a one bedroom, that's 1747. So if it is a one bedroom, if it's a studio, let me look that up real quick. Fair market value for a studio would be 1534 for a studio. So the issue is, if there is no bedroom, and a bedroom is a room that's a separate room, it's not part of the kitchen, that has a closet. That's what constitutes a bedroom. So if you've got a kitchen and a living room, and then you got two other rooms, and one is a separate room, but it doesn't have a closet, then that's generally going to be considered, it's not going to be considered a bedroom. It's going to be considered like a den or something.
Okay, here's another question. Leonard on YouTube. We do have a bunch, so we'll try to get through these. What if one of the two tenants moved out 7 months ago? He broke the lease and does not live there anymore, but signed the lease. Do I put his name on the notice? I do not know where he lives now.
I think we discussed that. If the ex-tenant is not living there, there's no reason to put his name on the notice. You're not going to, normally a process server, if he can find one person at home, he'll make what they call subservice on the other people who are not there. But if you know that the person is not living there, that would not be considered a good service. So there's absolutely no reason to name him in the 3-day notice or to sue him in an eviction lawsuit. If you do believe that the guy's coming back, maybe he's on an extended trip or something to that effect, and he hasn't really given up the unit, that's a different story. But if you know the guy's moved out, do not put his name in the notice. Does that mean you can't sue him for rent owed because he signed a rental agreement? And the answer is yes, of course you can, but that would be more like a small claims court suit.
So what if the current tenant calls him back up and says, hey, come back, I just got served a 3-day. So then are we, what's going to happen?
I don't think that's going to happen. But then again, most notices say to the named tenant and all others in possession. So
yeah, the others in possession. Yeah.
Yep.
Okay, there we go. David on YouTube, regarding the payment should be payable to on the 3-day notice, what do I do if the property is held in a trust?
Well, it depends. It's whatever you want your payment and to be made payable to. On the rental agreement, it should state who you make the check payable to, but it can either be the name of the trust, or which you'd have a bank account for that, or it could be your individual name. But whatever's on the rental agreement is generally what you should put onto the notice as to the entity or quote person who to pay the rent to.
Okay, Irene on Facebook. Does the 3-day notice have to include the clause, state law permits tenant to reclaim abandoned personal property?
That's only for a notice to quit, like a 30-day notice or a 60-day notice. It is not included in a notice to pay rent or quit, or even a notice to perform or quit, either of those.
Okay, and then number 2, does the landlord have to sign the 3-day notice?
There is no signature required. You can just print your name, and there is no requirement for that. So that would still be a proper notice.
Okay, CA Properties. My tenant stated, use my security deposit. The contract states security deposit is for unpaid rent. They gave 30-day notice, but they're still in the unit.
Okay, so the tenants sometimes try to pull that laughable experience. Your position is that a security deposit is not to be used for current rent. It's only to be used once the tenant vacates. You have 21 days to account for that security deposit, where you can subtract for any rent owed. You can subtract for unusual wear and tear, and finally for cleaning of the unit. But a security deposit is not, under the law, to be used for current rent owed while the tenant's in possession. So when the tenant tells you, oh, just use that as my quote last month's rent or anything like that, you should immediately serve that tenant with a 3-day notice.
Okay, and then it says they gave a 30-day notice. So you're probably gonna just be going through all of that, and then they're gonna leave anyway, huh?
Correct. Or they could be stalling and saying, hey, I don't have any money on November 1st. Let me just tell the landlord that, hey, use my security deposit. I'm going to be out in 30 days. And then in 30 days, the guy says, well, I can't find a place. So you've just now wasted 30 days. That's common ploy that tenants pull.
All right, Mike on YouTube. What if the tenant pays with a bad check?
Okay, so I'm going to expand on your question to say, I served a 3-day notice. He paid within the 3 days, and then the check bounced. What's that situation? I think that's what your question is. And in that situation, if the check bounced, it means he didn't pay within the 3 days. So you don't have to serve a new 3-day notice, even though you took his check, even though you endorsed it and cashed it, because it came back. So on that basis, you can just immediately proceed forward with the unlawful detainer.
All right, Leonard on YouTube. Can you please clarify, if you put the bank account, do you still need the address?
If you put the bank account, you need the address of the bank, which has to be within a 5-mile radius of where the tenant is living. And again, you have to have the hours of the bank, your name, your phone number, a name of the bank, account number, address of the bank, and hours upon which the bank is open.
Great. Okay. Let me see if I can find Kendall. When issuing a notice and the unit is in a trust, do we present ourselves as the trust entity or the John Doe trustee? Again,
if you're talking about serving a 3-day notice, it's based on what the rental agreement states. If you're talking about a tenant coming in, you could either do it individually, John Smith, or you can do it, the John Smith Revocable Trust, and that's who I want my payments made to, and I'm the trustee of the trust. So it really depends how you structured the rental agreement.
Okay, YouTube, AJ, how do you include an adult occupant that is not on the lease?
Again, you don't have to include an adult occupant who's not on the lease. You only have to put into the 3-day notice to pay rent those people who signed the rental agreement or those people who pay you the rent.
Yeah. Okay. Facebook, Abe, can we raise the rent 7% February 24 in the city of Los Angeles? The answer is no. Just yesterday, they came out with a revised deal where it's going to be 4% plus 2% if you're doing both of the different utilities. So that's just really
I love
incredible.
how the LA Times came out and said, Well, landlords are now able to raise the rents up to 6%. So they're making it out like it's 6%. But what they don't tell you is the rent increase is, and even 6% is bad, by the way, but it's only a paltry 4% unless you supply the electricity and the natural gas, which most people don't out of most rental units. So they're basically telling you 4%. And by the way, if you are supplying the electricity and the natural gas in addition to the water, do you think 2% is going to cover that for a month? You'd be so far behind the 8 ball that you've got to figure out a way for your units not to, when new tenants are coming in, that you're not paying for their utilities.
Yep. Okay, Walnut Creek LLC. What if you have a drop box? How do you note that on the notice?
That's very interesting, and that's actually very doable. So on the address to pay, you write the address of the building, 1234 North Anywhere Street, comma, rent collection box. I have one of those in my building, in one of the buildings, where they just drop there, and that's perfectly permissible to put it in there at that time. So that's a good one. I like that one, in fact, that you have a rent collection box right on the premises.
Yep. Manohar on YouTube. What do we do if after we file a case, the tenant deposits either full or partial payment, which you can't?
Good question. And that happens a lot. The tenant will Zelle money into the person's account. They'll deposit it directly. Now, if the tenant owes you, let's say 2 months worth of rent, and he Zells you $2 million, at that point, I just keep it and be quiet. But if he's only putting in a partial payment, see, his thought is, well, you know what, I'm going to throw $100 in. And then I know that since the landlord accepted money after the 3-day notice expired, he won't be able to win his case. Well, that's true, except that the landlord, once he finds out about it, should just take his, assuming that the funds have cleared, take your personal check and send it to the tenant for that amount of money with a note saying to the tenant, you've made an unauthorized deposit into my account, and I am sending you back my check. Now, what happens if the tenant doesn't cash it? Good. Great, because you've established that you're in conformity with the law, and if he doesn't want to cash it, great. And then once the tenant's ultimately evicted, I'd quickly put a stop payment on that check.
Yeah, and then one little convenient thing that we do have in our property management software is that you can just turn off the ability for them to pay rent if you don't want to receive it after whatever. And also you can set it up. It's already by default. They have to pay the full rent. You'd have to enable partial payment for them to be able to make a partial payment. Okay, here we go. Enrique, if you're using a tenant portal, how do you write that on the 3-day notice?
Well, again, you can make reference to that tenant portal and how you go to pay it, but that can't be the sole remedy. You're going to have either an address and a person who to pay, or you can do a regular bank account. So I would make that like a third option. Mm-hmm. So that doesn't, even if the tenant's Zelling you the money and that's how he pays, I'd still use an address or that bank account. That doesn't prevent him from Zelling it. And if he Zells it within 3 days, then the tenant has complied.
All right. You too, Meta. What percentage of UD cases are successful?
Generally speaking, in the area of law, it is a plaintiff who decides to bring forth a case. A defendant never chooses to bring forth a case. The defendant just gets sued. Oh my God, I'm getting sued, right? He didn't bring forth the case. So it just as a practical matter, regardless of what type of action you're bringing, as a traffic accident or a breach of contract or something to that effect, plaintiffs generally win the case because they chose to bring forth. They realized that they had a case. So in our cases, most of our cases are won. A lot of them settle, but we still win. Most of the cases are what they call uncontested. The tenant doesn't fight us, so we win automatically. Or if it does go to court, then and the tenant doesn't settle, we do trials, and we're mostly successful in all the trials we do. We're exceedingly successful, believe it or not, with regard to jury trials. If it goes to a jury trial, I would say 9 times out of 10, we prevail on a jury trial. Now, lots of times it doesn't get to a jury trial. And most landlords think, Jesus, I'm going to be going to court. There's going to be these 12 jury persons, and they're all going to be tenants, and they're going to vote against me. And that's not the case. We're really successful, and I do have some excellent attorneys on staff, but we're really successful in winning jury trials when they do finally come up. They come up rarely that we actually, a lot of people ask for jury trials, but when we're finally picking a jury, usually the other side caves in and the matter is just settled. But generally speaking, plaintiffs do win their cases, and my firm certainly does.
Great. All right, John on YouTube, we just want to welcome you on here. Is the 3-day notice for the property in Redlands and Yucaipa in the San Bernardino County sufficient?
Absolutely. The forms that the AOA puts out are perfect for those areas. We're going to do a couple more, Jeff, because got to get back to my phone,
Right. Let me see here.
And by the way, we talked about this. This was going to be, I love this. Jeff says this is going to be about 20 minutes. Oh, yeah, 20 minutes. Yeah, I think it's going to be 20 minutes too. Where are we? We're almost running into an hour and 20 minutes. So I guess we got lots to talk
the
about.
presentation was going to be 20. Questions will go on for a long time. So we're saving you work right now. People would be calling your phone, but now they can just go home, right? Or stay home or whatever. If a tenant didn't specify rent on the check, can you then apply it to late fees first?
And the answer is no. It's the debtor that determines what he's paying for. So if the rent's $2,500, you're going to say, I'll take the first $50 and I'll apply it towards the late fee. You can't do that unless the tenant specifically authorizes that in writing.
All right, let me see. I'm going to pick one last one because there's a few more here.
Make it a good one.
Okay, so CA properties, can you lock a tenant out of a garage if not paying and it's not under the rental agreement?
Well, if you had a separate agreement to pay rent for the garage, that becomes like a commercial tenancy and you have to go through a regular eviction. You just can't lock them out. Self-help in the state of California is frowned upon. So unless you're defending your home, I guess. But other than that, you're going to have to go through an eviction for the garage.
Yeah. Thought it would be good if we didn't leave them doing something like that. So thank you for answering that question. And again, thank you for joining and everybody for joining, and join us next week. We're going to be talking about laws that are coming up for 2024. And man, there's just all different types of ways that things are getting more restrictive, and we push against it. And I think we lessen some of what it could be, but we all need to be active on that. And I do want to say, like, even with the LA City, that housing council the housing committee meeting, it was great to see multiple AOA members that were there for the first time. There's the usual suspects, the AOA members that show up all the time, but then having a few extra where it was your very first time. I thought that was really cool. And again, just my advice is when it gets to the full council meeting, it's pretty much too late. I think Dennis, what he used to call it is the kangaroo court. And it's kind of like, it's like when it's a football game and you're up by a point and you're just hoping the other team doesn't make that field goal. And that's what the city council meeting is. But it's great to be there. I'm not knocking it, but I'm saying if you're in the housing committee meeting, then you have a shot at actually blocking the punt before it even gets up in the air. And to me, my odds, I feel like I like the odds of blocking it there than just hoping it doesn't sail through the uprights. So there's my little football analogy for the day. And anyway, best of luck to all of you. I know there's some serious heartburn, and so I wish you peace and hope you're able to sleep well with everything going on. Definitely consult with an attorney. Again, like this stuff, it really can't be legal advice. It's just these are some best practices, and to help you. Again, like 85% of these these notices are not prepared properly. So just remember, it's not an easy task. And hopefully we'll see you next week. And thanks again, Dennis. We appreciate you.
My pleasure. Thanks, Jeff.
Okay. Bye-bye.